Welcome, everyone. We'll wait just a few seconds here to let everyone join, and then we'll begin. All right, we'll go ahead and get started. Welcome to this Red Alert webinar titled The New Lawsuits Against Employers and Brokerages and the Advisor Opportunity They Create with Nelson, Griswold, and Jen Berman. So I will turn it over to Nelson.
Thank you, Kendall, and welcome to this Red Alert webinar. This is a big deal, and I have with me a nationally recognized expert to talk about this from the legal perspective. I'm going to talk about it from the voluntary benefit perspective. As some of you may know, my background in the industry was involuntary, and for many years I wrote a column, Benefit Advisor magazine, on voluntary, and was considered something of an expert. So we'll talk about that a little bit, but more importantly, the implications of this for both employers and for brokers and agencies. And we're going to talk about that in depth. And then at the end, we're going to give you some next steps that you can take to be proactive around this with your employer clients if you are an advisor. If you're an employer, you will have some tools that you can utilize to protect yourself against the liabilities and exposure that's coming from not just the lawsuits, but the fallout from these lawsuits. So let's get this going. So this is a Red Alert webinar, and I just wanted to show off the graphics again because I was really pleased with what the graphics team came up with. So this is about the new lawsuits against, and this is what's important, employers and brokerages. More important, the advisor opportunity they create for independent brokers and advisors. So what is it? It's this is a new wave of ERISA lawsuits. We've seen ERISA lawsuits around 401k fiduciary failures by employers. This is different. They're ERISA lawsuits, but they're targeting employers on employee benefits, on insurance products, and these voluntary benefits, and brokers. Brokers are no longer witnesses to this in these cases. They are named defendants. So what's at issue? Employer fiduciary duty is the underlying issue. This is the exposure employers have. But also broker compensation and self-dealing by brokers without taking the employers and the employees' best interest into consideration. Here are the real issues, and I'm going to talk about these in some depth as well as will Jen. Failure of employer fiduciary duty, the misaligned incentives in our employer-sponsored health plans, lack of transparency, which makes it easy for these brokerages to get away with the self-dealing, and no broker fiduciary duty or broker fiduciary actions, responsibilities, a posture that they're taking. They don't even pretend that they are working on the employer's behalf. It is all for the benefit of the brokerage, for the agency. Now, for those of you who know my background and know what I do, I am the founder and chief evangelist for Next Gen Benefits. I want to take a minute to talk about why I'm talking about this, why I think this is so important, and why advisors who are already on the transparency, fiduciary posture approach are extremely advantaged. And I want to talk just a little bit about Next Gen Benefits, because Next Gen Benefits provides a foundation to avoid all of the problems that these brokerages are having, being named in these lawsuits, and their employer clients are having. So I want to talk first just about our vision. Our vision at NextGen Benefits is very simple: the highest quality health care, accessible and affordable to all Americans, starting with the employees of our clients. This is what motivates a lot of NextGen advisors to get up in the morning. This isn't just about transactional insurance or health care. This is a mission. This is a crusade to save the private American healthcare industry, what's left of it, and restore it to a position where employers and employees and all Americans have access to affordable health care, the highest quality affordable health care. NextGen is about a number of things. It's about transparency, both on compensation, on plan design, on expenses that employers have, transparency across the board. Aligned incentives. One of the biggest problems in American healthcare is misaligned incentives. NextGen aligns those incentives. High performance health plans. This is where the rubber meets the road. This is what makes the difference. These are generally, not always, but generally self-funded plans using independent, non-BUCA, Blue Cross United Cigna Aetna, non-BUCA administrators with cost containment. We are about C-suite engagement. Real decisions in companies happen in the C-suite, the CEO or the CFO. We work with the executives in a company. And then finally, we believe in fiduciary standards. We believe in treating the health plan as though we were the employer, looking out for the employer's best interest. Doesn't mean we don't make money, doesn't mean we don't make a profit, doesn't mean we don't get paid well for what we do. But all of that is apparent to the employer, and all of it's done with the employer's best interest first and foremost, never our best interest first and foremost. We do this, NextGen advisors do this with a template we call the tool set, the skill set, and the mindset. Tool sets are the tools you use. They're the easy part. The skill set, more challenging. This requires learning some new skills. And then the mindset is totally important, because this is where your mindset changes from I'm a broker selling an insurance policy to an employer for an insurance company to I am a consultative advisor working on behalf of my employer client in his best interest to provide a high quality health plan that controls both cost and quality of care. Our NextGen benefits operating system has 4 basic points. The first is consultative selling. This is not a transactional arrangement. This is helping employers solve problems, find solutions, and improve the operations of their business, not just their health plan. Selling the C-suite. Again, these changes have to happen in the executive wing. HR is a tremendously valuable partner in all of this, but CEOs and CFOs make decisions about funding of healthcare and about changing the healthcare plan and the approach that is required with NextGen type plans. Selling self-funding. If you cannot help an employer understand why self-funding is not just not risky, it's no riskier than fully insured, 0 additional financial risk. If you can't explain that, they'll never move to self-funding, and therefore they're stuck in fully insured with the BUCA carriers. And then finally, once you're self-funded, you have control of the health plan, and you can exercise cost containment strategies to control both the cost and the quality of care. So this is the operating system we use, and we get results. In fact, results are all that matter. I can give you all sorts of rhetoric and strategies and techniques and tactics, but at the end of the day, if I don't deliver results, what good are they? So, meaningful bottom line results for employers and employees. This is doing the right thing, doing well by doing good, taking care of your clients. We deliver health plan dividend checks to our employer clients. They're getting money back, money that they put into the health plan that they didn't spend. Why didn't they spend it? Because we're managing the cost of care. and the quality of care. High quality care actually costs less. So here's a $62,000 check to a small nonprofit in Nashville. That's money they didn't have to go fundraise. That's money that went straight to their mission that before had been wasted on their health care. 188, almost 189,000 to TPHS in Texas. Bill Hughes is the advisor here. Bill's on the left. This was a remarkable $386,000. Remarkable. It says 188, but it's 386,000. That's wrong. John Clay, second to right, second to left in the picture, 780,000 to a governmental entity in Kentucky. That's taxpayer dollars that didn't get squandered on healthcare that had been wasted the year before. Here's a small wine store in Burlington, Vermont, getting back almost $37,000. That is a lot of cases of wine to have to sell to make $36,000. Steve Hartman with Associated Affiliates in Burlington. Ben Connor, second from the right in the picture on the left, delivering a check to a small nursery outside of Indianapolis for $88,000. That's a lot of money coming back that had been going to the health plan for no reason. Better health care plan, less money. And then finally, this one blows me away. First year of a new plan with John Harris, who's on the right. John Harris took a 400 life credit union, actually less than 350 life credit union, and saved them 1.23 million in the first year. Now, when you can do things like this, when you deliver results for your clients, you get results as an agency, as an advisor. You can close more business because you can do what the other brokers won't do. They could. None of this is rocket surgery. But they won't because their business model is set up differently. We use a different business model. So here are some of the results that we've seen with next-gen advisors around the country, taking mid-market groups from bigger, even national brokers. So 300 lives from USI, Rob Winfrey in Wichita, Kansas. Beth Johnson in Sikeston, Missouri, 250 lives from Mercer. Ben Connor in Indianapolis, 300 lives from Aon. Dan Thompson out of Naples, Florida, 1,200 employee lives from Willis, WTW. Gallagher lost 420 life group to Randy Hansen in Seattle. Shabsai Shakatowicz in Chicago took 600 lives from the Alera Group. Marcy Heath out of Bremen, Georgia, outside of Atlanta, west of Atlanta, took 130 lives from Marsh. Ed Legande, who is in the LA area, 800 lives from NFP. When you can do that, you grow your business. You become a dangerous, dangerous competitor in the market. Oh, a couple more. Oh, sorry. Brock Bertrand, 205 lives from Hub. Go back. Mike Hill, Brock is out of Fayetteville, Arkansas. Mike Hill out of Grand Rapids, Michigan, 1,200 lives from major regional player Highland. Don Shuey out of Jackson, Wyoming, 125 from Brown and Brown. And Dan LeBrod out of Dallas, 170 lives from Lockton. These are the kinds of results you get with these strategies. This is a group at our Ascend conference. This is from 2023. They get the Giant Killer Award for taking 75 lives or more from a larger agency, often a national agency, as you'll see here. These were some of the brands, some of the brokers that they took business from, this group standing on stage. So, results. We get results in NextGen. All right. When you understand all of that, now you are going to understand the opportunity that is there for advisors who will work on behalf of the employer, step away from the insurance company as your primary partner, and focus on your clients, and be transparent, act in a fiduciary manner, and you can get these kind of results, and there's a tremendous opportunity. So let's bring in our guest expert, Jen Berman, my dear friend out of Baltimore, Maryland. Jen has her, but not just her law degree, but also an MBA, which gives her a unique perspective in analyzing legal matters, not just from a legal perspective, but also from a business perspective. Jen understands business. She has run a business, is not just an attorney. She's been a very, very successful businesswoman for a number of years. Not that long, Jen, because at your age, you couldn't be doing it that long. She is now the chief legal officer at Loomlight, which is a large compliance corporate entity that Jen sold her business, MZQ, to a year or two ago. So Jen is nationally recognized as an employee benefits attorney. She happens to be the director of compliance for Next Gen Benefits. We are very grateful and proud to have her. And her expertise, her opinion, her insights have been featured in a ream of national media outlets because she is extremely well recognized and well respected as an authority on employee benefits, compliance, ERISA, and on and on. So, Jen, welcome to the webinar.
Thank you.
All right, let's dive in. So, Jen, do you remember the name of the guy on screen, the character?
Absolutely not, Nelson.
Oh my gosh, this is the star of the 1950s into the 1960s TV hit Dragnet, which was reprised a number of years ago by Dan Aykroyd as the lead character, Joe Friday, Sergeant Joe Friday, who was famous for simply saying to a witness, "Just the facts, ma'am." Well,
All right.
let's let's give the facts of this situation. What are we dealing with here? So these are lawsuits, 4 lawsuits, very similar. They're class actions against employers on behalf of a class of employees. Jen, you're familiar with the main actors here, Schlichter Bogart, and the name partner and I think, the genius behind the work that Schlichter Bogart does, Jerry Schlichter. You want to tell us what
Absolutely.
your
So
thoughts about them?
I certainly will. So Jerry Schlichter and company are super famous in the ERISA world because they are responsible for millions of dollars in recoveries on behalf of plaintiffs in the retirement plan arena. So they've been around a long, long time and have been very successful on theories just like the one that we have now seen introduced, suing defendants on in that retirement plan world. So if we go back a little bit, we first saw fiduciary lawsuits about, I guess, 2 years ago now, in February of 2024, get introduced in Lewandowski versus Johnson & Johnson. That's when this conversation started for us in the health and welfare space. But ERISA cases on fiduciary duty go back decades, and Jerry Schlichter and his firm have been the most successful in this space of really anybody. But this is the first time we've seen them cross over into our world of health and welfare lawsuits.
Jerry Schlichter is known as the father of the 401k lawsuit. He has recovered for his clients $750 million from employers for failure of fiduciary duty around their 401k plans. I got a call about 2 years ago, Jen. I think I mentioned this to you.
Oh, yeah, we talked about it then.
Yeah, from Jerry Schlichter, who had been I'd been recommended to him. We had a long conversation. It was fascinating because he realized that he had been stepping over dollars to pick up nickels on the 401k side because the spend, the employer spend, the dollars at stake here on health plans dwarfs the 401k. So the 401k opportunity. So Jerry was extremely enthusiastic about this opportunity. I declined an opportunity to consult on. I could have been a consultant on these, but I thought it was just not the right thing for me to do. But Jerry Schlichter's a brilliant guy and very, very successful, and does not take cases just, and this is interesting and important, doesn't take cases just to win a settlement. When he starts in a new market, and this is a new market for him, he is looking to establish precedent. He's willing to take cases to the Supreme Court knowing he can win.
And we're going to talk about voluntary benefits for the next few minutes. I want you to listen to this carefully and understand why we're talking about voluntary benefits. It's not really about voluntary benefits. So we will explain this over the next 15 or 20 minutes, but know that the voluntary benefits is for a very specific reason. It's about that precedent word that you said. But this is not at all, it's a little bit about voluntary benefits, but we're not picking on voluntary benefits. We're trying to establish a legal theory, or really it's not we, it's our friend Jerry who's trying to establish a legal theory.
It's funny. Ann Lewandowski posted on LinkedIn just the other day about all of the recent developments that I think you and I are going to be back on another Red Alert webinar on around PBMs in particular. But the DOL has issued a rule for comment, still in the comment phase. The Congress passed legislation around PBMs and changed the CAA language around compensation disclosure, which
covered service provider definition, all new. We'll probably be back next week, very soon.
Another conversation, but big. And a number of other things happened that week, last week.
Yeah.
Cigna's share price went up.
Think about that.
Now, when recently, just recently, when the AI company that competes with OpenAI, and I'm thinking blank, it's Claude, the one that does Claude, Anthropic. When Anthropic issued some new tools for Claude that have the potential to devastate, to do all of the work that SaaS, software as a service, is doing, you saw a precipitous drop in the share value of Salesforce and a number of other large software as a service companies. You have all of these big occurrences in healthcare, and Cigna's stock goes up. And I made the point to Ann in a comment back. Well, shareholders and savvy investors understand that the BUCAs know how to leverage any change to their advantage. They will find a way to make it work for them. And I mentioned that a couple of years ago, I just told Richard Branson about the misaligned incentives in American healthcare. And he reminded me, Nelson, you realize that companies will not change their behavior until their incentives change. So I said to Ann in the LinkedIn post, whether it's market changes that we affect, like with what we're doing in Next Gen and other organizations and other individuals are doing to change the market, to change the incentives, or if it's litigation that changes the incentives, or, and don't hold your breath for this one, regulations or legislation, but they never gets enforced. So really, even if it's passed, it almost never gets enforced. We have to change the incentives of the BUCAs, or they will continue to do what they're doing, and understandably so. We would too if we were in their shoes. Okay, so Jen, you're absolutely right. It's not about voluntary benefits, and we both have something to say about that. Let's talk about the defendants in this case, and maybe not so much how they were picked, why they were picked, which is really more of a legal tort issue than anything else.
So they just they have bad luck. I don't think that they're very special in this regard. In some ways, they just have bad luck. Um, so and Nelson, you're probably as well positioned to comment on this as anybody. So these folks have voluntary benefit programs in place. They do not have fiduciary committees in place. They do have their voluntary benefit plans subject to ERISA. So it is already a fact for purposes of this case that they are being treated as ERISA plans. So please take from your mind that whole is the voluntary exemption happening or not happening issue. It's not on the table. By the way, just public service announcement, voluntary benefit plans almost never qualify for the ERISA exemption. If you think yours does, call me and I will explain to you 96% of the time why you don't actually qualify for that exemption. It's silly, and you almost always have endorsed it somehow because you fell into the trap. But if you want to try, we can have a chat. All right. So these guys are the defendants in the case, and just kind of ripe, easy targets. Big plans, lots of employees, and easy to come after. Any other thoughts on that, Nelson?
Well, they're not alone.
No, they are not alone. Their brokers are too, but their brokers are not being sued for fiduciary duty breaches. Their brokers are being sued on a prohibited transaction claim. So there's two different things going on here. There's the fiduciary duty breach, failed to act in the best interest of plan participants, and we'll talk about that and how and why in a minute. And then there is this concept of a prohibited transaction. So when we are dealing with ERISA, there is this concept that you cannot do business, you cannot pay a party in interest, somebody who is related to the plan, unless you qualify for an exemption. The exemption says you can pay somebody related to the plan, doing services for the plan, if that compensation is reasonable. And so the brokers were joined in this lawsuit, are also defendants in this lawsuit, based on the theory that their compensation is not reasonable. How do we know if their compensation was reasonable or not? Well, the pleadings would say that their compensation is not reasonable, and they tell you how much they were compensated. How do we know how much they were compensated? It's on the 5500. So they're looking at the medical loss ratio, the loss ratios, not medical loss ratios. These are voluntary plans. They're the loss ratios for these plans, and they're saying that they were paid too much relative to the overall cost of these plans. Were they paid too much? We could have a conversation around that. That will be up for the courts to decide. But that's why these folks are being sued here. So we all have opinions on if they were paid too much, but that's what this is about, is how much they were being paid. Not their fiduciary duty to the plan, because they are not actually fiduciaries. They are not making discretionary decisions with respect to the administration of the plan.
The primary targets in this are not the brokers.
Nope.
It's the employers, because they are the deep pockets. So follow the money is always good advice. These are tort actions being pursued by a tort attorney who makes his money 33% of the award or the settlement that the employer pays. So deep pockets. Joe's Plumbing down the street with 3 plumbers and a receptionist is not going to be sued on this. But there are implications both for employers and employees, and we're going to get to that. All right. The target, as we said, is voluntary benefits, the ostensible target in these suits.
And I want to talk about why for a minute. What's different about voluntary benefits, Nelson?
Paid
it was
by
your
the
world.
Paid by the employees who clearly then have standing. They have been harmed. Therefore, they are eligible to be part of a class. How'd
exactly.
I do?
Beautiful. Beautiful. And not only are they paid and they have standing and they're harmed, but it's 100% paid. by the employee. And so when we want to follow the money, it is absolutely clear that all of the dollars are employee dollars. This is going to be iterative. Once once Schlichter wins his voluntary benefit cases, he will ramp this up to the other bigger dollar benefits. But the easiest class to certify and the easiest sort of place to deal with the standing issues is going to be involuntary benefits. So the things that make the J&J and the JP Morgan and the existing cases harder to win are proving harm and proving standing. But in the voluntary benefit space, all of the plan dollars are employee dollars. We don't have to worry about things being paid from general assets and is the money really the employee's money or is the money the employer's money? In the case of voluntary benefits, every dollar associated with that plan is an employee dollar. So there's been a lot of talk since this came out about, why are we picking on the voluntary benefits industry? And is it about kind of the load and the amount of comp that brokers are paid? There's certainly conversation to be had about what brokers are paid in the voluntary benefit space. That's not why this is where the Schlichter started. He started here because it's easier from a standing perspective. Doesn't mean that's irrelevant. It just means it's not the reason from a legal theory perspective.
The thing too about voluntary benefits is for years we have lived in fear of something like this that forces voluntary into the ERISA into the ERISA fold. We have always said, oh no, they're not ERISA plans because it's easier. It's much easier to deal with them that way. So here's the core theory of the case, Jen. If you want to just, I mean, it's people can read it. They've probably read it already, but the key here is the plan fiduciaries failed to run a prudent process.
Yep.
To ensure that their employees got a high quality product at a fair price that paid fairly. That's really loss ratio. I think everybody knows is just what percentage of each premium dollar did you pay out in claims.
Yep.
And voluntary benefits have notoriously low loss ratios. In other words, they're very profitable, in large part because people buy them and then forget they have them. And as someone who sat down with employees for a number of years and would talk to them during open enrollment, you said, did you get to use your accident plan this year? What accident plan? It's like, bet you're glad you had that critical illness policy since you had cancer last year. I'm so grateful. What critical illness policy? Let's file a claim right now. So they forget. So it's a legitimate issue. The loss ratios are a legitimate issue in voluntary. The commissions, I never thought they were out of line, frankly, but there's a lot of work to do voluntary and a lot of expenses to do voluntary. So it's not like it's all profit to the broker. But these are the key points of the case. So what does this mean for employers, for your clients, and for you as an advisor? So I'm going to pull Jen up full screen and come back with you. Jen, talk about the implications for employers. And I don't mean the ones who have been sued. I'm talking about all employers. What does this, again, most employers are not going to get sued by Jerry Schlichter or his ilk. That's a bullet that they can reasonably expect to dodge. But there are other implications, I think, around fiduciary duties that employers need to understand and their advisors need to understand. This is shifting the goalposts.
It 100% is. And, I've been talking about this the last couple of years. ERISA is ERISA, retirement plan world and the health and welfare plan world. And these concepts basically say that you have to be evaluating your vendors, you have to be making prudent decisions, you have to be acting in the best interest of your participants. and beneficiaries. And so there's a couple of things that have to happen in order for that to be the case. First off, you have to be acting in the best interest of your participants and beneficiaries. It's kind of basic, everything I know I learned in kindergarten stuff. In addition to be acting in their best interest, you have to be documenting that you are acting in their best interest. Maybe you didn't learn all the documentation in kindergarten. I think I learned to write my name at that point. So maybe not all of the documentation. But from the perspective of, the annoying lawyers like me in the world, if you didn't document it, it didn't happen. So I would venture to say that most of my clients do, in fact, act in the best interest of participants. They do evaluate multiple vendors and they do make prudent choices based on those vendors. But they don't go through the process of recording that information, and they don't necessarily deliberate in a way that is fully documented. And that's really what's going to need to change. And what we're going to see change. So history can be our best teacher. And, Jerry Schlichter didn't ultimately sue everybody, but we did see the practices in the retirement plan world change. And we saw that change not only for employers, but also for their brokers or advisors. So I think very few of us could honestly say or stay with a straight face that most of our clients do not sit down and evaluate the investment options and the fees related to those investment options in their retirement plans. But 25 years ago, they didn't. They didn't have committees to do that, and they didn't do that evaluative process. They probably did think about it, but they didn't have all of that documentation in that process. That is where we are going, and it's going to become necessary to sit down to form those committees to do that process and to do it and to record it. So again, it's not that they're not doing it. They're probably meeting with the people who are listening to this webinar right now and having the conversation. But they may or may not be including other key stakeholders from the business. So HR, CFO, key decision makers within the C-suite. Different folks at different times are involved in making the decision. But are they sitting down together to deliberate on it and recording it? That's what's going to change. And we want to be the front end of that wave, not the back end of the wave. Make sense?
Makes perfect sense. How do you think this moves through the ecosystem? How does this ripple? What's the ripple effect here?
So the good actors with the best principles are going to obviously be the ones who do it first, right? So if you're already transparent, if you already have those good tools and are already making those good positive decisions, they're going to be the ones who become the early adopters here. We already referenced a few minutes ago that, these things tend to come in waves, right? So we scheduled this session, I think the beginning of last week, at a time when it wasn't clear if the CAA of 2026 was going to pass or not, and if it was going to pass, what was going to be in it or not. And then it passed last Tuesday night. And in it, we've already referenced this, and we will certainly do a full session on this. We got comprehensive PBM reform, and we got a change to compensation disclosure that broadly changes who's going to have to do the compensation disclosure, which is going to dramatically change the fiduciary review process. So we're talking about this voluntary benefit lawsuit and what that means and what it needs to be to do that fiduciary review process. But now let's talk about the fact that even compensation disclosure and what it means to do compensation disclosure is different, and technically it's different today. So I promise a deeper dive on this shortly, but it's no longer just brokers and advisors who are subject to compensation disclosure. Now it's basically everybody in the health plan ecosystem, from your TPA to your general agent to your record keeper to your compliance services provider. Everybody's subject to compensation review. So beyond just the fact that all of those providers have got to figure out how to get their compensation disclosure done, what's your client going to do with all of those compensation disclosures? How are they going to review and benchmark them? These are big questions that need answers, and it's going to have to be those fiduciary committees that create those answers and create those processes around it.
You know, it's the advice, the guidance that the advisors can give their clients. That do we think they're going to get a lot of guidance and advice from Gallagher around these processes? I don't think so. I think you're going to get very little. These are the people. Well, let me give you a quick example of what's happening. One of our mastermind members, our Next Gen Benefits mastermind members, was a finalist for the voluntary and ancillary benefits at a large hospital, 8,000 life hospital. His fellow finalists were Mercer and Lockton. If you'll go back a couple of slides, you will have seen Mercer and Lockton's name as named defendants in this lawsuit around voluntary benefits. The advisor told me, "Do you think I sent the Bloomberg article on these lawsuits and Mercer and Lockton being named to the hospital, to the decision makers?" Right? You have an opportunity to be different. You have an opportunity to pick up the cudgel, is the old expression, and metaphorically beat your competition around the head with it, because they can't defend themselves. They are their business model. This is their business model. Their business model requires them to do these things. This is how they make money. The Bucas are no different, by the way. In a lawsuit in Boston, in Massachusetts, a labor union, health and welfare committee had sued Blue Cross of Massachusetts for failure of fiduciary duty. What Blue Cross was doing was overpaying providers, overpaying them intentionally, and then going back to the provider and saying, "Hey, you were overpaid, need to claw that back. We need to get that money back from you." Because this was a self-funded plan, in the Administrative Services Agreement, the ASA, Blue Cross was entitled to keep 40% of any recovered overpayment.
So let's use that. So let's talk a little bit about some of these other fiduciary principles and things that folks are not necessarily doing, that there's a profound need for. So we talked about voluntary benefits being sort of the first stage of this next lawsuit. There are obviously fiduciary lawsuits pending in the health plan, the medical plan space as well. But this highlights the importance of things like doing independent claims audits, right? So there's a tremendous need to be looking at your TPAs and confirming that the claims are being audited and being processed correctly, whether we're with a BUCA or not. There's also a tremendous need to be doing dependent eligibility audits. The deeper I get into this space, the more shocked that I am at the percentage of folks who are participating in plans and are not technically eligible for those plans. All of these fall within the realm of fiduciary duty. So they are all compliance obligations, to the extent that it is a plan sponsor's legal responsibility to ensure that plan assets are being managed correctly. If you have an ineligible participant in the plan, they tend to be oftentimes the highest spenders in the plan, or if you have claims being processed incorrectly. So it's not just a matter of that process and setting up those committees and having those meetings and doing that compensation review. It's also sort of that good plan hygiene and making sure you've got the right claims for the right people being paid the right way. All of that is part of this fiduciary ecosystem. So I know people just love me these days now, Sen. They're like, "Jen, could you uninvite yourself to my party?
Did you say, did I hear you say plan hygiene?
I think you did.
That's hilarious.
I know. That's why
Um,
they uninvite me. They're like, I come in and I start talking for a minute, and they're like, "That's the door."
um, there are um, so let's do a just a quick role play of the conversation an employer might an advisor, an independent advisor whose business model is not. Oh, I didn't finish that story, Jen. Blue Cross, in defending itself in this lawsuit in Massachusetts, said, and I paraphrase, but it's not far from the original language in Blue Cross's response. If we were to be held to a fiduciary standard in the area at issue, in other words, intentionally overcharging the provider so you could claw it back and keep 40%. If we were held to a fiduciary standard on that matter, we would have to change our entire business model. In other words, their business model is premised on taking advantage of, is the nicest way I can put it. I think larceny comes to mind as another word. Theft comes to mind as another word. But taking advantage of their clients for their own benefit at the expense of their client. Brokerages are set up much the same way in terms of business model. We do things to benefit the status quo brokers. We do things to benefit our bottom line, our revenue stream and our bottom line. But it's not in the best interest of the employer. Well, that's unfortunate. Mm. So the fiduciary standard would be, let's take a look at what's in the best interest of our client, and let's do that. And then make money the right way. Make money because you're helping your client pay as little as possible, helping your client provide the highest quality health care, helping your client achieve their business goals because they're not overpaying on health care and they're not disenfranchising their employees for being able to afford health care, or hurting productivity because morale is low because no one likes the health plan, they can't afford it, et cetera. So this is a big piece of it. So how does that conversation go? Just how would they get started with that if they are a truly enlightened independent advisor?
I think that the beginning of the conversation is really sitting down to say, let's talk about your goals and objectives, right? And it's no different than any other conversation. Like, what are your needs, and what are you trying to accomplish here, right? It's every sales conversation that you've ever had, and then we walk through our tool set. What we're doing here is adding another tool to the toolkit. And that new tool is that fiduciary. Maybe it's a few tools. It's our fiduciary. It's our fiduciary little. Maybe it's a little section for the toolkit on fiduciary tools, which include setting up the committee, working through the committee process, and doing that evaluation.
Okay. It's beautiful. I wanted to say a couple of things before we get to the next steps that we want to share with people that they can take to help protect their clients and also gain a competitive edge. The voluntary benefits is basically, it's a back door. And Jen, you alluded to this. It's a back door to get into the health plan, establish a failure of fiduciary duty on the part of the employer. Now, where can the attorneys go with that? How can they expand that now that they have the employer dead to rights on failing to exercise fiduciary duty and exercising that responsibility to their employees? You know, I think too, a lot of this is getting the court to understand that employees are affected by this. Well, with voluntary, there's no question. It's as Jen, as you pointed out, the employees pay for these products. They receive the benefits of the products. So if it's a low loss ratio, in other words, I buy an accident plan for $150 a year, and they're only paying out 30 cents on the dollar. That's probably not a very good plan for me. I don't know that I can expect great benefits from it. So not paying attention to those things. Well, of course, who's really responsible for this? Well, the employer legally has a fiduciary duty, but the employer has delegated that fiduciary responsibility to the broker. Problem is the broker has never accepted it and in fact would tell you, oh no, we're not a fiduciary. We couldn't possibly be a fiduciary. That would destroy our business model because most of the money we make is at the expense of the employer. So here's where I see a big opportunity for advisors, in addition to stepping up and having this conversation around more broadly fiduciary duty and the steps that are required to do it, but specifically around areas like provider compensation, broker compensation. How do you know what the benchmark is? Are they getting paid too much? Are they providing all of the revenue streams that they actually have? Well, the employer doesn't know that. They assume that signature by the brokerage means they are telling everything. Are they? I find that extremely hard to believe because I don't believe most employers will ever hear from Gallagher or Brown and Brown or Lockton that we're making $2, $3, $4, $5 per script, per prescription that your employees fill. I'm pretty sure no brokerage is going to tell the employer that because it's unconscionable. Because that's money right out of the employees and the employer's pocket. PBM pays them that because they have to get the business. So having those conversations, but the other aspect of this that I think is profound, is these lawsuits are making very public the bad behavior of the status quo brokers. Now, I don't mean voluntary benefits per se. I'm a big fan of voluntary benefits. I drank that Kool-Aid a long time ago. I love voluntary benefits. I think they're great for the employees, but there are better products, better pricing for those products. The question is what consideration goes into which carrier to offer? Is it the products and the pricing on those products for the employees? Or is it the higher commission? Or is it the awards trip at the end of the year? If you qualify with X amount of premium written, you get to go on one of these glorious trips. I never got to go on one.
Hey, Nelson, do we have any solutions to help people?
Well, we do,
Okay.
Jen. Let me bring back up our You're watching the time. Thank you for that, Jen.
You're welcome.
Let's see here. Zoom. There is. Here we go. So next steps. If you like the dance steps, so that was kind of clever. Okay. To protect your employer clients. I'll let you speak to this because this is a Loomlight program that you put together for this very purpose and with a special offer for webinar attendees today?
Yes, indeed. So this is a Loomlight program, our fiduciary shield practice, with a special offer for the webinar attendees. So what we have done is to put together a few of the different Loomlight products that we have to help protect fiduciaries. So what this includes is our fiduciary governance foundations, which is access to our fiduciary dashboard, which gives them access to fiduciary training, as well as all of the governance tools that are necessary to allow them to put together that fiduciary committee and walk them through that process, a place to keep all of their fiduciary governance materials, a vendor performance audit, giving them that, we talked about those claims audits, so access into a claims audit, as well as a prescription drug audit if they would like that, so they can choose between one or both of that medical audit or RX audit, because it's really not just about the voluntary benefits, as we talked about. The medical plan is really where the most liability is. Ongoing audits to the extent that that's necessary, and the dependent eligibility. So once we put together all of those things, that is really a package that's going to give them that true fiduciary protection that they are looking for. And for anybody who reaches out to our team and lets them know that they were here today on this webinar, we will give a 15% off discount. Well, 15% discount. Alternatively, we can pass that discount on to you or to them, however you would like to do that, as a thank you for joining us today.
And to get more information on that and to sign up for that, there is a QR code that you can avail yourselves of right now. So quickly pull your cameras out and do that, because I have to go to another slide. I'll bring it back up towards the end, right at the end. All right, next steps. If you, as an advisor, want to get a huge, massive competitive advantage, and I suspect you do, Jerry Schlichter and these lawsuits are giving you that opportunity. Some of you may be familiar with the Validation Institute. I happen to serve on the board of the Validation Institute. They validate vendors on their claims, their marketing claims. Do we actually lower the price or the cost of surgery? Do we improve the health in this area, what have you? It's all data-based. Fabulous organization. But recently, they introduced a fiduciary validation, and they will validate you as an advisor or your firm, if you meet the criteria, as a fiduciary benefits advisor or a fiduciary benefits firm. Not only will they validate you and give you the paperwork for that, but they will also put up a $100,000 guarantee. If you are sued for any reason, they'll provide, your E&O will provide the first $100,000. They'll provide the next $100,000 of any penalties. Now, Al Lewis is an attorney by training. He's a brilliant guy, runs the Validation Institute, is the chief validator, as he puts it, CEO. And he said, Nelson, why do you think I can do that $100,000 guarantee? I said, well, have you got like an insurance company backing you? Nelson, I'm never going to have to pay it. Fiduciary advisors aren't going to do things that are going to get them sideways. That's not possible. As long as they hew to their, if they don't violate their standards, they will never get sued. And if they violate the standards, they're not eligible for $100,000. So you do the right thing, there's $100,000, but you'll never need it. That's how sure Al is of this. So Next Gen has an arrangement for a substantial discount. I think it is 50%, but don't hold me to that. It's substantial though. We've had several Next Gen advisors. Terry Shook is one. Paul Flowers is another, who have gone and gotten validated as fiduciaries. Others in the industry you would know of, David Contorno is a validated. Donovan Pyle is validated fiduciary. There are a number of others, and the number is growing. I would urge you to do this, and here's why. Because you don't then have to point at your competitors and say, do you know what they do? You simply say, here's what we do not do. Here's how we act as a fiduciary on your behalf. By the way, this is a small f fiduciary, not a capital F fiduciary. But it simply says we're operating under fiduciary standards, and you lay those out. Now the employer, gets to make a comparison. Well, surely Gallagher's doing this too. Let me check. You can urge them to check. So if you are interested, here's the website, validationinstitute.com/fiduciary. If you want to go right to the fiduciary page, validationinstitute.com will get you there. You can navigate from there. But these are 2 steps that you can take to have a conversation with your client and establish yourself as different. Do we believe that Mercer, WTW, Gallagher, or Lockton are going to be bringing up these lawsuits and the need to establish fiduciary compliance? I doubt it. I doubt it seriously. By the way, if you're offering voluntary benefits, you might point up that you don't operate the way they do. Do your due diligence. And I promised I'd bring this back up for those who wanted the QR code. So validationinstitute.com/fiduciary. Jen, we're a little bit over, but last word.
Thank you all so much for joining us. Feel free to fill this out. If you have any direct questions, you are also always welcome to email me directly at jennifer.berman@loomlight.com.
Thank you, Jennifer. Always a pleasure. We will be back in a week or 2 to talk about these PBM developments, the regulation, DOL regulations, and the new legislation that affects not just PBMs, but also other service providers in the industry.
Just everybody.
Well, everybody. So for Next Gen Benefits, thank you for joining us. Make it a fantastic rest of the week. See you soon.